Okay, well, it being 1 o'clock, we'll start with session 4, which is on transparency. My name is Cheryl Samuels, and I'm the ASPG National Secretary. I recently retired after 34 years as a parliamentary officer with the New South Wales Legislative Assembly, and before that with the House of Representatives. Prior to retiring, I worked as a research officer with the New South Wales Legislative Assembly Committee Office, and previously as Deputy Sergeant at Arms. Before I introduce our presenters, can I remind everyone about the ASPG General Meeting that will commence at around about 3 p.m. at the conclusion of this afternoon's session. This will be a Zoom meeting, and participants will need to exit the webinar and join the meeting by Zoom. The AGM is open to ASPG members and conference participants, and if you would like to attend but have not yet received a Zoom meeting invitation, can you please contact Rachel? Now, in this session, we have 3 presentations. The first one is from Associate Professor Julia Debeljak and Associate Professor Laura Grenfell. Dr. Debeljak is an Associate Professor in the Faculty of Law and academic member of the Castan Centre for Human Rights Law, and was formerly a Foundation Deputy Director at Monash University. She teaches and researches in the areas of international and comparative human rights law, domestic and comparative human rights instruments and implementation, and constitutional and public laws. She has published widely across a range of human rights topics, with a strong record in the area of domestic implementation of human rights obligations and comparative human rights instruments, including recent focuses on human rights in closed environments and aged care. She recently co-edited and contributed to Lawmaking and Human Rights, Executive and Parliamentary Scrutiny across Australian jurisdiction with Associate Professor Laura Grenfell. Laura Grenfell is an Associate Professor in the School of Law at the University of Adelaide. She researches in the areas of human rights and public law. Raqeeb Bhuyan is currently Senior Research Officer in the Committee Office, Department of House of Representatives. Raqeeb has worked at the Department of House of Representatives since 2018 and holds a Bachelor of Arts History and a Bachelor of Science Mathematics from the Australian National University. And Aleshia Westgate is an Acting Committee Secretary in the Department of the House of Representatives. Aleshia has worked for the Australian Parliament for much of the last decade, including in the Other Place and Australian Hansard, and has supported a number of Senate Joint Select and House committees. I welcome our first 2 presenters, Julie Debeljak and Laura Grenfell, to speak to us on lawmaking and human rights, executive and parliamentary scrutiny across Australian jurisdictions. Over to you.
Okay. Hello, everyone. I'm going to share a screen first. So if you just bear with me, I will start a slideshow from the beginning, and I will get this is one good thing that has come out of COVID, my ability to actually do PowerPoints whilst presenting. Okay, I think we're ready to go, Laura. Yep. So hello, everyone, and thank you for inviting us to present today. Laura Grenfell and I co-edited this book, Lawmaking and Human Rights, Executive and Parliamentary Scrutiny Across Australian Jurisdictions, and it was published in 2020. The book really focuses on 4 main areas of scrutiny. The first is the federal statutory human rights scrutiny system. The second part is about the subnational statutory human rights scrutiny systems in the ACT and Victoria, with some analysis, comparative analysis, to New Zealand and the United Kingdom. The third part looks at the scrutiny structures and processes in other states and territories that do not have specific human rights instruments. And finally, part 4 focuses on scrutiny in the context of some contemporary areas of lawmaking. Today, however, our focus is going to be on our introduction and our conclusion to the 25-chapter book. So we're going to begin with key themes that came out of all the chapters. So firstly, and you don't need to know this, I mean, you already know this, across Australian jurisdictions, the protection of human rights really comes down to our representative arms of government, guided by constitutional principles such as responsible government, representative government, and parliamentary sovereignty. Most Australian jurisdictions do not have human rights instruments that allow for judicial scrutiny of the rights impact of laws and policies on individuals. Even in the 3 jurisdictions that do have a judicial role within a human rights instrument, such as the ACT, Victoria and Queensland, those particular frameworks actually preserve parliamentary sovereignty with respect to human rights. So obviously the primary responsibility sits with Parliament for human rights protection. Now, if we focus in on parliaments, we first note, obviously, that you've got the role of being constitutional, the constitutional roles of being legislative scrutineer and sovereign lawmaker. However, the influence of human rights over this legislative scrutiny and lawmaking role differs across the jurisdictions, as this slide indicates, and I'll move on to the next slide too to show it in a diagrammatic form. So some jurisdictions do have specific human rights legislation that require human rights committees to consider all laws for compliance with human rights standards. So at the Commonwealth, they have a dedicated human rights committee, and they look at all of our international human rights obligations: civil, political, economic, social and cultural rights. In the ACT, Victoria and Queensland, they have generalist committees that mainly consider civil and political rights when they're scrutinising laws. There are also other statutory mandated parliamentary committees that have got scrutiny roles. However, they rely on common law standards as the standard for review, and that happens in New South Wales, and it used to happen in Queensland before they got the Human Rights Act. Then we have various ad hoc systems of scrutiny. So, for example, in the Northern Territory, they rely on parliamentary sessional orders to actually undertake scrutiny. Otherwise, some jurisdictions rely on the mixed membership of the upper houses to either refer a bill to a parliamentary committee for scrutiny, such as in WA, or to themselves perform legislative scrutiny of the bills, such as in Tasmania and South Australia. So that's, in essence, the parliamentary landscape, if you like. The next feature that came out in our book was the fact that we have executive dominance, okay? Influencing all... Sorry, I can ask that you couldn't hear me. How long ago could you not hear me from?
I think around about executive dominance, Julie.
Okay. The joys. Okay, so clearly, should I continue or should I repeat myself?
Yes, can you just repeat yourself, please?
Okay, so in terms of the tension between parliamentary sovereignty and executive dominance, I think you're all aware of the fact that it's pretty much near impossible for an sorry, I'm being a bit thrown, sorry. It's near impossible to achieve an amendment to legislation, let alone a rights-based amendment, once the executive's cabinet has approved draft or proposed legislation. So this obviously weakens Parliament's ability to keep the executive accountable. Parliament cannot actually test the human rights implications, or cannot even figure out whether or not the executive has considered human rights implications when it's developed its policy and legislative proposals. And it also undermines the claim that parliaments are best to protect human rights through proactive policy development and lawmaking informed by the views of the electorate they represent. So Parliament tends to rely on parliamentary sovereignty as a reason to resist post-enactment judicial scrutiny of legislation under human rights instruments. But if Parliament struggles to keep the executive accountable for the human rights impact of their policy and legislative agenda, that brings into question the very sovereignty of Parliament as lawmaker, and thus it weakens the argument against judicial enforcement of human rights. Now, another thing that came out of our edited collection is that there are really 2 phases of human rights scrutiny. The first is what we call upstream, and the second is what we call downstream. So upstream occurs before basically the bill is enacted, and there are 2 elements to this. There's the pre-introduction upstream scrutiny, which refers to the scrutiny that the executive undertakes the law as it's developing the policy and drafting its legislation. And this is before anything is introduced into Parliament. There is also the post-introduction upstream scrutiny that takes place once a bill is tabled in Parliament, but before it is enacted. Now, this contrasts with downstream or post-enactment judicial review, which tends to be judicial review, where we have a human rights statute involved. The diagram on this slide just goes to show that this can be cyclical in nature. You might end up with some post-enactment review that then feeds into a new draft of legislation or a change in policy. Another thing that came out of our edited collection is the benefits that we get from human rights scrutiny. So there are three main benefits I want to talk to you about today. The first is transparency. Human rights focused scrutiny should identify and explore the potential rights impacts as policies being developed and laws being drafted and enacted. This transparency leads to accountability, okay? If we have transparency in the development of legislation and policy, it's key to holding policy developers and lawmakers accountable for the rights consequences of their decisions. Thirdly, effective scrutiny should involve a culture of justification for any impacts on rights of the policy or the legislation. This ideally includes the following three things. So firstly, we get an acknowledgement where a proposed law is engaging or limiting human rights. We can then assess whether the objective being pursued by the rights limiting law is actually legitimate or reasonable. And then we can also ask whether the rights limiting legislative means chosen to pursue that objective are demonstrably justifiable. Now, various questions get asked under that third question, such as, are there any less rights restrictive means available to achieve your objective? Is there proportionality between the benefits of your rights limiting legislative objective and the detriment that you're causing to rights by your legislative means? Also things like safeguards. What safeguards are in place to protect people's rights? So the last key theme that I want to talk to you about is this idea of the fact that even if you are under human rights scrutiny via a rights mandate or a non-rights mandate, similar issues pertain. So, for example, even if you have a human rights statute, parliamentary sovereignty and executive dominance still play a role. Okay, all the human rights instruments do not undermine parliamentary sovereignty, and nor do they interfere with the executive's dominance in policy development and lawmaking. The other thing to keep in mind with all upstream scrutiny, again, whether it's statutory or non-statutory based, again, whether it's rights focused or not rights focused, is that they are all impacted by the political culture and dynamics of the institutions within which they operate. So our edit collection really was trying to look at the upstream and downstream processes that engage with human rights to try and ensure a better engagement with rights in the lawmaking process. So yes, we present key insights as to how the institutions are operating at the moment. And then in our introduction and conclusion, we are hoping to identify for you future directions that will enable the executive and parliament to better engage with human rights. And better engagement, we mean greater transparency, greater accountability, and establishing this kind of culture of justification. But today, we only have time to focus on the upstream phases. So I will speak about pre-introduction scrutiny, and then Laura will speak about post-introduction scrutiny, and I'm going to address these two topics only. Firstly, lack of transparency. So in the pre-introduction upstream phase, obviously that's behind closed doors, it's outside of Parliament, and the executive is dominant in this scrutiny phase. So this confidential nature of this phase, combined with the executive dominance, makes it very difficult for Parliament to assess whether rights were considered in policy development and legislative drafting. Indeed, in one of the chapters, Reynolds and Williams indicate that most decisions affecting rights are now made in party rooms rather than parliamentary chambers, and thus well before any form of deliberation promoted by scrutiny regimes, and that by the time a bill comes to the floor of Parliament for vote, parliamentarians' positions are often entrenched. Now, obviously, this does not much for transparency, accountability, and generating a culture of justification. Turning to my second main point, vis-a-vis jurisdictions with statutory human rights instruments, all of these jurisdictions require proposed laws to be accompanied by either a statement of compatibility or a statement of incompatibility. This is the executive's opportunity to be transparent about and accountable for the rights impacts of the proposed legislation, and to justify to the Parliament and the people any limitations on rights in that policy or legislation. Now, a few key themes have emerged from the chapters vis-a-vis this part of the process. The first is really timing. In Victoria, as in most places, there's a two-stage cabinet process for seeking approval, okay? The first phase of approval in principle is where the cabinet basically approves the policy objectives underlying the proposed legislation and issues their legislative drafting instructions. Now, these submissions are informed by human rights and the potential for incompatibility with human rights, but as Davidson flags, this consideration is necessarily at a higher level of generality, and it focuses on key policy objectives and designing a framework for achieving those policy objectives, okay? It is only after the approval in principle is secured that Parliamentary Council actually starts to draft the legislation, and the statement of incompatibility is then drafted. Obviously, the bill and the second materials then go back for a second phase at the bill at cabinet phase. Now, the problem is that it's during the drafting phase that rights are really identified, and the reasonableness and justifiability of any limitations on rights are actually teased out. As Humphreys, Roberts and Cleaver confirm, the narrowing of legislative limitations on human rights in order to meet the proportionality test is a constant conversation during this phase, which is great. However, the sequence of this process poses two obstacles. The first is halfway down the chain. Okay, one of the key scrutiny items, a statement of compatibility, is usually prepared halfway through the process rather than at the start of the process. Secondly, many authors agree that once you've got a proposal passed at the first approval in principle phase, the opportunity for changing it later are very limited, because any significant change to the policy or legislation requires you to go back to this first phase and seek a new approval in principle. So there is a strong disincentive to alter policy or legislation once a statement of compatibility reveals the detailed human rights impacts. The second theme is who drafts these documents. In Victoria, the drafting of statements of compatibility is actually decentralised to the relevant portfolio, so the minister and their department. Many authors consider this to be a great strength, because that means that the minister and the department actually take carriage, if you like, of the human rights. They engage with rights early, they take responsibility for the rights impacts of their policy decisions and their legislative developments, and it tends to create a strong culture of avoiding making statements of incompatibility, which in turn means ensuring that policy and legislation conform as best they can with human rights protections. But this brings me to an interesting third point I wish to make, statements of incompatibility. As you all know, the executive may attach a statement of incompatibility to proposed legislation. Now, this is very important, okay? Firstly, it's important because Parliament remains sovereign. Parliament is allowed under these human rights instruments to enact laws that are incompatible with human rights. Secondly, however, it forces the executive to be transparent about the rights impacts of the law it proposes, and that in turn opens the executive up to electoral accountability for enacting laws that unjustifiably violate rights. It also supports this culture of justification. The executive has to admit that it cannot justify the legislation in human rights terms. Now, what's interesting here is the numbers. In the ACT, no bill has been presented since 2004 with a statement of incompatibility. In Victoria, since around 2007, I think they started, 8 bills have been presented with a statement of incompatibility or partial incompatibility. But in New Zealand, since 1990, they've had 80 laws attached with a Section 7 inconsistency report. Half of these were government bills, and a large proportion of these bills were actually enacted into law. Now, why do we have these differences across the different jurisdictions? Well, firstly, we think about who drafts these statements. In New Zealand, the statements are drafted centrally by the Attorney General as Senior Law Officer of the Crown, not as a Minister of the Crown. Davidson, in her chapter, argues that this ensures independence of the rights assessments and allows the AG to criticise the government's policy. So in other words, we have more independent and more technical review of the proposed legislation vis-a-vis human rights. This contrasts with Victoria, where, as you know, the Minister drafts a statement of incompatibility and compatibility, which means it is not independent necessarily, and it's much more focused on the government's policy reasons for the impacts on rights. The second issue is really a timing issue. In Victoria, as you know, the statement of the rights are really considered somewhere between the first and second cabinet phase, which is relatively early in developing the proposal and the legislation, which means that legislation can usually be altered to accommodate any rights issues and to make the legislation rights compatible. But in New Zealand, the Section 7 compatibility statement occurs after a bill is actually presented to Parliament. Now, as many people argue, including Davidson, this is often too late. The capacity and willingness of the government to make significant changes to a bill once it's tabled in Parliament declines, okay? So this brings me to best practice, where I draw these threads together. It really is the ACT model that emerges as best practice. The real game changer here is the inclusion of the ACT Human Rights Commissioner in the pre-introduction scrutiny process. So as Watchiers, Costello, Intelligaratnam explain in their chapter, the ACT Cabinet practice grants the Human Rights Commissioner access to Cabinet submissions, okay? So she's involved both in the first pass stage, where Cabinet agrees on a policy and to the drafting of legislation, and the second pass phase where they agree on presenting a bill to the Assembly. Now, the Commissioner says this has given her a unique opportunity to influence policymaking early in the process. They also confirm that the Commissioner's input is taken very seriously, and in the overwhelming majority of cases, the relevant directorates took the Commissioner's comments into consideration and made necessary changes. In the opinion of the three authors, this has ensured a high degree of healthy contestability about human rights assessment at the pre-legislative scrutiny stage. So what are the key factors here? There is definitely consensus that the earlier rights are accounted for in policy and legislative development, the more fully rights can be considered and adequately accommodated. And here, Victoria certainly has an advantage over New Zealand. Moreover, independent input is also a factor to getting more robust assessments of the impacts on rights. And here, New Zealand obviously has an advantage over Victoria. However, it is really the twinning of both the independent scrutiny with early scrutiny that takes the ACT process another step closer to ensuring a cultural justification for rights incursions and enhancing the transparency and accountability in public decision-making impacting on rights. Now, nevertheless, it should be acknowledged that in the ACT, the Cabinet is not obliged to alter its proposed legislation based on the Commissioner's input. So this underlines that the pre-introduction upstream scrutiny process must always be paired with the robust post-introduction upstream scrutiny process that happens in Parliament, and we'll turn to Laura for that.
Thank you very much, Julie. I'd like to just acknowledge that I'm speaking from Ghana country. So my part of this presentation will just focus briefly on the post-introduction scrutiny phase. And this is obviously after a bill is introduced into Parliament and before it is enacted. Now, this is a stage that is obviously much more in the public eye because it's mostly recorded in Hansard, and this provides greater transparency. So this is the point at which we should be able to see the executive and parliament offering justification for policy and law choices and how they impact on human rights. And here we should be offered the evidence base for these policies and laws. So one of the questions asked by our authors in the collection was whether the executive is sufficiently forthcoming at this point. In other words, how much accountability is there at this point of the legislative process? So we might start with the systems where there is no human rights scrutiny. That's right. So these are informal systems of scrutiny, and these are really mainly the smaller parliaments, as you can see, but I've also included New South Wales because New South Wales does not have a system of introducing statements of compatibility along with bills. So in the smaller parliaments, there is this absence of an agreed set of rights standards, and this makes the scrutiny process so much more ad hoc and unsystematic. So to gauge whether the executive has considered human rights implications of its law and policy, the public needs to rely on secondary materials like the second reading speech and the explanatory memo, but these secondary materials do not systematically set out how the policy or law meet any particular rights standards. And indeed, in South Australia, my home jurisdiction, we don't even have explanatory memoranda. So the quality of the evidence offered then really relies on a range of factors. Firstly, what are the priorities of the government at the time and whether they prioritise setting out the human rights implications of their law and policy choices. Secondly, the skills of individual MPs really affects the quality of the evidence. And thirdly, the campaigning efforts of various stakeholders and whether or not they can make submissions which set out the rights implications of bills. So how does this impact on lawmaking? Well, it particularly impacts on the crossbenchers who really don't have the resources and time to be able to do this sort of research themselves. And so reading the Hansard debates, you can see that a lot of them are quite frustrated and really in a difficult position in this regard. Now, there are, though, our edited collection showed us, though, that various jurisdictions have got some things that have upped the level of the quality of evidence. And one of them is Tasmania, and Tasmanian government introduced a centralised parliamentary means of collating all the stakeholder submissions made to members of parliament. And this obviously makes it so much easier for the public and for crossbenchers to be able to gauge the rights implications of laws. In contrast, South Australia has no such centralised means of collating submissions, but the research indicated, though, that South Australia has quite an effective House of Review. So it has, the upper house has not been controlled by the government since 1976, and hence the upper house does in fact work, and has at least until recently, as a proper House of Review. But this very much relies on the skills and priorities of individual MPs in the upper house and whether or not they've had legal training and what their interests might be. If we turn now to the parliaments which have formal statute-driven human rights-based scrutiny, here we're really looking at the fact that these parliaments have systems of statements of compatibility, and our authors found that unfortunately the quality of statements of compatibility in our federal parliament is often quite low. But this is not inevitable, we found, because if you look at the ACT scrutiny process, you can see that there is a higher quality, but it is actually the details not set out in these statements of compatibility, but instead in the explanatory statements. Now, in terms of the quality of Victorian statements of compatibility, this was actually fairly contested. What was quite interesting is that some of our authors who had actually worked in government were quite favourable in their evaluation of these statements of compatibility, as opposed to some of our academic researchers who found that the quality was less consistent. Finally, our newest comer to a system of having statements of compatibility is the Northern Territory, and my own research showed that this system is very new and possibly that these statements are not taken very seriously. Okay, so in terms of these parliaments which do have statements of compatibility, we didn't see any correlation between having statements of compatibility and a greater volume of references, a greater sort of debate about human rights. So there is no correlation between a greater volume of rights debate and having these statements of compatibility. And we found, unfortunately, that the engagement with the scrutiny reports is often very low on the floor of Parliament. We can see, though, that there are divergences, and in the UK there is a different experience. There's much greater engagement with scrutiny reports on the floor of Parliament, and this could be to do with the standing and status of the UK's Joint Committee on Human Rights, but it also points to other factors relating to downstream scrutiny. Our authors also looked at ministerial correspondence to see the dialogue between the parliamentary scrutiny committees and the executive, and the various authors found that one of the big issues here was timing, although also very much depends on the goodwill of ministers to really have a constructive and productive exchange with the parliamentary committees. And as you can see, Reynolds and Williams found that at the Commonwealth level, this was not always the case. Simon Rice also found that the way that ministers respond to parliamentary committees can be, in fact, quite perfunctory, dismissive, and even impolite. In terms of Victoria, our researcher Mo felt that there was very little deliberative value actually in these ministerial responses because they often failed to actually address the concerns of the parliamentary committee. Okay, now we just will touch on how committees can run inquiries, and can obviously inquiries give a greater opportunity for the Parliament and the Executive to hear from a more diverse range of stakeholders. And this really distinguishes this phase of scrutiny from the pre-introduction stage, where often the government just consults with the usual suspects like the Law Society. And we heard in a great session this morning how important this public engagement is. Thank you to Dr. Moulds for that. So our authors found that at the Commonwealth and Victorian parliaments, there is unfortunately quite a low level of public engagement with committee inquiries, and they put this down to issues such as timing and resource constraints. It's possible that Queensland has a higher level of public engagement, but this could really be making up for the fact of not having an upper house. I also wonder about COVID-19 and whether this has actually brought about greater public engagement with parliamentary committees. And certainly there is a greater public interest in understanding the choices of governments in regards to policies and laws, because these COVID laws impact on a greater number of people and their rights than ever before. So just to conclude, finally, look, I think that there are too few incentives for Australian parliaments to elevate the standing and status of parliamentary scrutiny committees. There's too few incentives to generate a stronger culture of justification. And I think there's too few incentives to increase transparency in regard to human rights considerations at play in law and policy making. Thanks very much.
Okay, thank you, Julie and Laura, for a very interesting presentation. Our next presentation is from Raqeeb Bhuyan, who is speaking to us on welcoming web robots to Parliament, realise benefits of open data. Over to you, Raqeeb.
Hello. All right, I'm just going to try to share my PowerPoint slides. All right, so my name's Raqeeb. So I work at the Federal House of Representatives Committee Office. I'd like to acknowledge that where I'm presenting from today has been the meeting place for the Ngunnawal and Ngambri peoples for thousands of years. And I also extend my respects to any Aboriginal and Torres Strait Islander people present with us today. So this paper is a revised version of my paper that I produced for the ANZACAT course in 2020. And I'd like to thank Philippa McCormack for her feedback on this paper. And I want to talk specifically about a couple of examples of software projects created by the public and what the relevant open government lessons these examples illustrate for parliaments. And I hope that providing some visual examples will make some of the technical details I've tried to describe in my paper a bit easier to understand. So what is a web robot? So I'm sure we're all increasingly aware of internet bots that spread disinformation on social media. And when I was working on the Standing Committee on Petitions in 2020, we also had a lot of discussion about how do we avoid robots fraudulently signing e-petitions. However, not all internet robots are malicious. One example is that since the late 90s, the National Library of Australia has been sending web bots to download Australian websites, which include Australian parliamentary websites. So this example here shows the points in time where the National Library or the Internet Archive has sent effectively a web robot to download the website, and that's viewable on the Trove platform. And then citizens more broadly have been collecting data from parliamentary websites, including setting up web robots, and that's what I've looked at in this paper here. And I am being a little bit facetious in calling it a robot, but effectively they're just pieces of software that automatically visit a web page, download data from it, and try to gain some information. So I'm also thinking about the way open government data expectations apply in a parliamentary context. I think a theme that's been the case is that open government policies are being adopted at the executive level. So we can see that for the federal government, the Australian government adopted the International Open Data Charter. For the South Australian government, they have principles that they've adopted for the South Australian government's approach to open data. And similarly, Victorian government on their data.vic.gov.au provides one definition of open data. There's not a single definition of open data, but the general gist of it is generally that there's an expectation of public being transparent, making it public, that it's in a format that allows for machines to read it, and that it's in a permanent stable format, so where people can know where to find it from a consistent location. And when we're thinking about how this applies to parliaments, often justifications for open data and open government might be to stimulate the economy, which is what it says on the Victorian government website here. I'm not sure if that necessarily applies to parliaments. I think what we're probably thinking about as a benefit is how open data from parliaments contributes to a more transparent and accountable society. And in terms of open government, I have focused in on open data and the technology aspects. And I think from what applies here is the way that open government principles have reflected a shift in expectations on what it means to be a transparent institution. And we've certainly seen cases with members' interest registers where to be viewed as a transparent institution, it's an expectation that you're publishing documents on the internet. And beyond that, through groups like burntheregister.com, we can see that there's an expectation in the community that it's not just PDFs that are scanned that are uploaded to the website, but that it's machine readable PDFs. So what I did in this project was to look at journal articles where researchers have described using data from an Australian or New Zealand Parliament and how they process the data. And then I also looked at open source software repositories, so github.com as the main one, where I could look at software projects that people had uploaded online and where they've then also published the code for their software to see exactly which data they've obtained and which and what they've actually done with it. I'm taking a broad meaning of data here as well. So by data, I really mean anything published online by parliaments. So that can be things like minutes, such as the votes and proceedings, Hansard, committee reports, the contact details of members. These are all examples of things that on github.com we can see the public has sought. And the other thing is that I think often the discussion around open data is justified based on the hypothetical benefits that technology may bring and what people may be able to achieve with machine learning, etc. That's not necessarily something that a member of the public will have the the free time and the resources to produce. So I think by looking at existing processes and existing uses of data, I think we can get a better sense of what the technical capabilities in the public actually are at the moment. So github.com is just a software repository where people can upload software code. They can, when they publish it, anyone can take a look at it. You can search through the code itself, and it also allows programmers to collaborate on their software. So what these kind of software projects are doing, so in my paper, I've got I guess details of some of them. So I'll highlight some here. And so this one, for example, is just a Twitter bot. What it's doing is that it's looking through the federal Hansard for examples of members saying, please, thank you, sorry, and then it posts it to Twitter. So that could arguably be quite a trivial thing. But on the other hand, it is an example of a way some member of the public has decided to engage with parliamentary data. And you could argue that maybe something like this can go to, changing impressions of parliament that may come from question time as a very adversarial and hostile environment to, there are examples of members treating each other with respect during most of the sitting periods. Some of these software projects very clearly motivated by wanting to hold Parliament to account and wanting to hold parliamentarians to account. So theyvoteforyou.org.au is an example of a website that scans through Hansard to extract division data, and then they, on their own website, present the results of divisions and then allow people to look at statistics on how their member or how a member has voted on various topics. So on the github.com, so the projects that I did find, they were very much skewed to the federal level. So there are examples of data from New Zealand, Queensland, etc. that I found on GitHub, but I didn't find any from Northern Territory. That might have changed. So this, I did look at this in late 2020. And then also there was a huge bias towards people wanting to use the Hansard data. So there are, I did find examples of projects that looked at committee submissions and scanned through committee submissions, or they might have looked through the parliamentary handbooks to get a list of members on certain committees or a list of, email addresses for members. And then I think the range of the work produced by the public evokes some questions in terms of if, things like Hansard and votes and proceedings are already public, what advantage does open data actually bring in terms of transparency? What expectations does open data place on parliaments as a publisher? And does parliaments have obligations that they should be fulfilling there as well? And what is the balance between what do you leave to the community and what should the publisher be doing? So one example of a clear advantage of why open data is better than just the already public Hansard documents is that it allows researchers to read through decades of Hansard very quickly. So a couple of examples of projects here are Rowan Alexander and Monica Alexander. They looked through federal Hansard from 1901 to 2018 and extracted a list of topics discussed by year. And then another example is a group of researchers, including Darren Halpel, which looked at interest groups and how many times a particular interest group in their interest group database is actually mentioned in chamber proceedings, and using that to assess, which interest groups are getting more attention from parliamentarians and how that's changed over time. And then the other thing that I found is that often the projects aren't actually like that. The information that the person is seeking isn't necessarily about holding Parliament to account. These are examples of one from Dr. Josh Gans and Dr. Lee, where they published a paper wanting to assess how partisan, or providing a measure of how partisan the media and various public intellectuals are, and they drew on Hansard there. And then another example from Jeffrey Ford in New Zealand, where his PhD thesis, it looks to be, was on lay people's understandings of the economy, and he treated parliamentarians as non-professional economists talking about the economy. So if we're then trying to understand how these pieces of software actually work, I think we can break it up into 3 high-level steps that the software is doing. So the first is they need to get the data. And then once they've got the data, they need to process it or parse it. And then once they've put it into a format that their software can work with, they can then gain the information that they're seeking. So in the case of that Dr. Lee, Dr. Gans paper, they didn't use automated techniques. They describe in their journal article that they employed a research assistant to make search queries on the APH Parlinfo website. And then similarly, so whereas with that Jeffrey Ford paper, it looks like what they've done is they've taken New Zealand Parliament Hansard from 2003 to 2016 and developed a linguistic corpora from that. So they are using automated techniques there to process a lot of information at one go. And I guess those data periods, both in those papers, were affected by they were restricted to the machine readable versions of Hansard that was available at the time they did their research. So that Dr. Lee paper was from 1996 onwards and then that Jeffrey Ford paper was from 2003 onwards. And so a subset of the github.com, so an example of another project now, a subset of the GitHub projects were actually uploaded to a website called morph.io. So this effectively looks to be a free service that a programmer can upload their code to, and then that website and that service will effectively run their program every day. And that way, this script, for example, was downloading the votes and proceedings of the federal House of Representatives and then also the Senate journals every day. And then it's processing it to then get a count of how many members turned up, attended that sitting day. And we can see 25 days ago, this code picked up on the March 2022 sittings of the federal parliament. And the main advantage of the github.com software repository is that you can see exactly where which web page they've taken the data from. So this is a code extract from the AusBills project. And this is, I guess, why I've also restricted myself to journal articles and open source software, because I guess while probably journalists are probably the most frequent user of parliamentary data, newspaper articles don't generally describe where they've gotten their data from and how they've had to process it. So this project here, this AusBills project, downloaded a page from the House Bills website, and it's an extract from this table. So this isn't necessarily open data, it's just a web page, it's HTML. So while the programmer can figure out how to extract the information that they're seeking about bills before the House, they've had to do a lot of work in extracting that information, processing it into a usable format. And then they're also at the risk of, if the layout of the website changes, their code may break. And this did occur with another project where a person was complaining that the House of Representatives bills website went from listing the long title of bills to the short title of bills. And that's something that, I guess, if there's not an intentional commitment from Parliament as a publisher to provide a consistent data source, we might not just necessarily know that people have started building software and tools on just what's been provided on the website as is. And beyond that, software breaks all the time. And for what seems to be just a hobbyist who's, sought to, keep track of members' attendance in the House and the Senate, that's 4 years that they've had to keep updating their software for. And an example of where code can easily be broken by changes in layouts of website is through this members' attendance, where I guess the way that, so once they've downloaded all the votes and proceedings, all they're looking for is, there's a paragraph at the end of the votes and proceedings that say all members attended at some time during the sitting, except, and then it lists the members that that didn't attend that day. So they're relying on, they know that the votes and proceedings, every time, if there's members that weren't in attendance, it has this exact same sentence. So all the software is doing is that it looks for that sentence, and then it looks for the list of members. But an example of where they're dependent on the unstructured data and the way that, and relying, I guess the main point is that they're relying on the votes and proceedings remaining consistent. So this, for example, if for some reason votes and proceedings started using an Oxford comma, a change in a comma or a misplaced comma would actually break their software. And then I guess that's presenting unstructured data as effectively just the votes and proceedings and the PDF or the HTML and just a whole paragraph of text. That's compared to structured data, which is generally what you'd be expecting an organization that's committed to providing open data to start fitting their data to. So I won't go too much in detail about this. I think the Jeffrey Ford 2018 PhD thesis has quite a good example in their appendices of how they've had to find machine readable copies of New Zealand Hansard, and then there's screenshots of what actually is structured data there. So I'd encourage people interested to look at that one. But essentially, structured data and open data standards are just a way of providing consistency for the programmers to find the information that they're looking for. So in the case of federal Hansard divisions, the theyvoteforyou.org.au website uses the structured Hansard XML. And to find the division data, they look for this tag division, and they know that that's not going to have a misplaced comma or some other inconsistency. So that's basically a consistent word that they're looking for. So that's the difference between unstructured data, where this person has had to find what happens to be consistent every time, a whole sentence, whereas structured data in the document itself provides consistent points. And then to end, just in terms of concluding remarks, I think what this means, if we think about the obligations of parliaments as publishers of data, is that we already consider, when we're publishing minutes, Hansard committee reports, that people that will be reading it in print. More frequently, people are reading committee reports, etc., on their mobile devices. So we're already trying to, the way that we publish our information needs to adapt to mobile devices. Then if we're thinking about accessibility compliance, we're already in a way thinking about machines in the way of screen readers reading the data. And then I think once you've satisfied those three things, you're actually probably not that far off from just publishing your information as structured data and thinking about how the machine as an audience, as another reader of information that's published on the website might be using that information that we put out. So that's, I guess, a quick summary of my paper.
Okay, well, thank you, Raqeeb, very much for that. Our final presenter is Aleshia Westgate, and her topic is Withdrawal of Strangers, Decision-Making in Secret.
Thank you very much. Just firstly, can everybody see and hear me? How are we going
yes, I
for
can
sound?
hear you.
Yep, great. Okay. I'm just going to share my screen. So just bear with me for a second. Sorry, I'm just a bit confused. Sorry, I'm just having some trouble sharing the screen. I can do it without it. It's not a big deal. So I might, I'll just have one go. No, it's not playing. It's okay. They were really just background so that people didn't have to look at my face for the next 15 minutes, but it's your loss. So I am also speaking to you from the lands of the Ngunnawal and the Ngambri people, like Raqeeb, and it's very fitting to be talking about meetings when we're on this meeting place that's a very, very long-standing tradition of holding meetings. And of course, I extend my respects to all Aboriginal and Torres Strait Islander people present today. So we are all strangers. We're strangers because we don't know each other and have no reason to trust each other. The ancient Greeks viewed xenia, the extension of hospitality and the change in status from stranger to guest, as incredibly important as a bond. Shakespeare in As You Like It gave a famous insult where he said, or one of his characters said, "I do declare that we be better strangers." In the parliamentary context, we are strangers because we are not members of the House and we're not in a legislature. Right now, we're also not performing our official duties in the chamber. On the 20th of August, 1941, the Right Honourable Robert Gordon Menzies KC, the Prime Minister and at the time Minister for Defence Coordination, drew the attention of the House to the presence of strangers. He said, "There are various aspects of the matters to which I have referred, which honourable members may think can be discussed more freely in a private meeting. I therefore direct the attention to the presence of strangers in the House." What follows is an explanation of what occurred in the 3 instances of secret decision-making in 1940 and 41. In particular, I want to draw attention to the context in which they occurred, the procedural mechanisms that allowed this, and then a discussion of some of the broader implications of these events. The concept of decision-making in secret is not unfamiliar to a modern democratic audience, and perhaps is best seen in the operation of cabinet, which has been called the apex of executive government, in which ministers are summoned by the Prime Minister to debate but ultimately arrive at a shared policy position. Public parliamentary debates, however, in which representatives come together to put forward a view or an argument and hear those of other members, are an important part of our representative democracy, and there's an expectation that the debate will be public. In other words, Cabinet is the secret internal debate to reach a publicly stated policy direction. Parliament is the public forum for consensus-based decision-making, and it's assumed that it will sit publicly and openly. Now, as with so much of our parliamentary procedural foundation, the Commonwealth Parliament shares with Westminster the ability to sit in private. Erskine May, notes that the use of the House of Commons Standing Order 163 is rare in peacetime, but in the event that it is required, any member may move that the House sit in private and the question should be put. If agreed to, the galleries are cleared, reporting staff must withdraw, the broadcasting ceases, and the chair may authorise a short suspension for all of this to happen. I'm going to contrast this very ordered and consistent flow of proceedings with the House of Representatives' use of this procedure, which changed each of the 3 times it was used. Now, the UK Houses sat in private during the First and Second World Wars. On these occasions, a 2-stage process was followed. First, the agreement to sit in private, and then the agreement to go into secret session, with the divulgence of proceedings of a secret session being a much more serious matter and engaging the provisions of wartime security legislation. In December 1945, the UK Parliament resolved that proceedings from a secret session of the last Parliament need not be kept secret. The Australian Parliament does not appear to have followed this, and I would say that the status of what occurred in the chamber is unclear at best. Now, I want to focus back on the House of Representatives. The traditional parliamentary term stranger has been noted as symbolic of the ancient privileges of Parliament, reinforcing the divide between member and non-member, and further reinforcing that outsiders are permitted within the confines of the precinct on tolerance only and not by right. In the House of Representatives, and representatives practice says this, a stranger was any person present in the chamber, including the galleries, who was neither a member nor an employee of the House of Representatives performing official duties. Parliamentary reporting staff as employees of Parliament were not normally regarded as strangers. Renamed visitor in 2004, the definition was changed to be a person other than a member or parliamentary official, and broadened in 2016 to provide that an infant cared for by a member was also not a visitor. Visitors may be admitted by the Speaker into the lower galleries, and distinguished visitors admitted to a seat on the floor of the chamber. House of Representative practice notes that the use of the motion that the strangers be ordered to withdraw without the expectation that it would be agreed to was used as a delaying or disruptive tactic many times. Former House Standing Order 314 provided for any member to put the question to be decided without debate. It was used on numerous occasions and does appear to have been a tactic of last resort in some cases. Now, our current House standing orders don't have an explicit provision for such a motion, but Standing Order 66D does provide for a member to interrupt another member to call attention to the unwanted presence of visitors. And let's hope they don't ever do that. I'm going to move now to a brief historical context for the uses of the order. And I feel that the political context of the time is incredibly important to understanding why they made these decisions. Now, Australia's involvement with the Second World War was announced on every national and commercial radio station in Australia by Prime Minister Menzies on the 3rd of September 1939. Menzies had been Prime Minister for just under 6 months and led a minority United Australia Party government after the death of the sitting Prime Minister, Joseph Lyons. Menzies also publicly announced the formation of the War Cabinet to be the main decision-making body on the conduct of the war. And it was originally a standing committee of the full cabinet. It was originally a body to discuss the conduct of the war, but it became much more prominent over its first year. Menzies retained power at the 1940 federal election, but relied on the support of 2 independents to do this. He offered to form a national government with the opposition leader, John Curtin, which was declined, and instead the Joint Party War Council was formed. Amid political instability from February to May 1941, Menzies travelled to meet Australian troops in North Africa and participated in the British War Cabinet in London. On his return, he found internal party support waning after open plotting against him. Menzies again offered suggestions for a national government, again declined. After an emergency cabinet meeting at which a majority of ministers agreed that a new leader was needed, Menzies resigned the prime ministership on the 29th of August 1941. In October of that year, the 2 independents that Menzies had relied on crossed the floor in what's a largely symbolic division, and the coalition government, by then led by Arthur Fadden, was brought down. John Curtin became the Prime Minister, went on to lead the Labor Party to a large majority in the 1943 general election, And in the written paper to accompany this presentation, you can find a bit more information about this and a little bit of trivia for anyone who's interested in that. Now, I give this historical and political context to illustrate the instability of a minority government at a time of crisis, the deep political divisions within the governing coalition, and the need for the Prime Minister to be absent for months at a time during all this. All of this political turmoil was played out in the papers, with news articles reporting on major and minor political machinations and gossip. The extraordinary offers of joint party government and efforts to increase political stability, however unsuccessful they were all part of unusual decisions being made during a time of crisis. Here are some more. During the debate on defence estimates between the 12th to 13th of December 1940, the member for Burke suggested that 12:30 in the morning may not be the time for what he referred to as tired men excited by the statements we have heard to be considering these matters, and requested that debate be adjourned to the next week when, quote, they can be disposed of in a calm discussion. I'm highlighting the member's own words here because he seems to be suggesting that decisions like these should not be made in the middle of the night. The Prime Minister noted a suggestion by then Leader of the Opposition, John Curtin, to discuss the matters in private. Prime Minister Menzies then directed the attention of the Chair to the presence of strangers. The Chairman, and I'm using this term because the House was sitting as the Committee of Supply at the time, put the question that the strangers be ordered to withdraw. The motion was agreed to on the voices, and recording of the debates was suspended from 12:32 a.m. to 3:30 a.m. Upon resumption of the recording of the debates, the proposed vote for the Department of the Navy was agreed to, and the debate then moved to the Department of the Army. Notable in this, the first time the House met to debate in private is the absence of any dissent from the motion, any discussion on the parameters of the meeting, and the fact that the House itself was not suspended, the recording of the debate was. Notable also is the fact that the vote was agreed to once the recording of the debate was resumed. So debate may have been in private, or discussion even, but the outcome of the decision was reported publicly and the amount of money was disclosed. The votes and proceedings, the official record of the proceedings of the House, recorded the proceedings in the private meeting. It says, debate continued, withdrawal of strangers. Mr. Menzies having taken notice that strangers were present. Question, that strangers be ordered to withdraw, put and passed. Chairman's ruling. The Chairman stated that he did not regard honourable senators as strangers. Debate continued. Ordered that Mr. Cameron be granted a further extension of time. Debate continued. Ordered that strangers be admitted. That's all we get. The second example on the 29th of May, 1941, when the House again agreed to the withdrawal of strangers. Prime Minister Menzies stated that honourable members may wish to be given some opportunity to discuss certain matters privately, and again directed the attention of the Speaker to the presence of strangers. The Speaker put the question and it was resolved in the affirmative on the voices. This time, however, the sitting was suspended from 3:15 p.m. to 11:21 p.m. It's a significant amount of time to be discussing anything without any record. Sitting resumed on the motion that strangers be admitted and the business continued. The Hansard recorded the topic of discussion as secret meeting of senators and members. The votes and proceedings recorded that the Speaker left the chair and then resumed it prior to the order that strangers be admitted. 3 minutes after the resumption, the House adjourned until the next day. The votes and proceedings does not record what happened during the suspension. Now, the last time the House sat in secret was the 20th of August, 1941, 9 days before the resignation of the Prime Minister. In the votes and proceedings, the order is swiftly put and passed, and proceedings were suspended from 3:55 p.m. when the Speaker left the chair, resuming at 10 p.m. Again, a significant amount of time. The House again permitted the presence of strangers, although did rub it in that they are strangers, agreed to the withdrawal of the recording staff and suspended. Unlike the other two instances, however, the Hansard record of the event illustrates the weight of the decision to deliberate in private and records the members setting out their concerns with the question. For the first time, the members actually discussed what they were about to do. Now, after Prime Minister Menzies delivered a lengthy speech on international affairs, a paper titled Recent Developments in International Affairs and Proposal that the Prime Minister should visit London was tabled and ordered to be printed, quote, in order that there may later be public discussion of this matter. It's perhaps ironic that the importance of public debate on this matter was acknowledged immediately before strangers were ordered to be removed. The debate in the chamber then moved to the nature of the meeting in private and the concerns of members, although the question was again resolved on the voices. On the question of whether reporting staff should remain, Mr. Speaker stated that, and apologies, it's a bit of a lengthy quote, by a very old ruling of this House, members of the official reporting staff are officers of this House, and they are not covered by the resolution excluding strangers. That rule, of course, was passed in times very much different from the present. There was no war then. If I interpret the wish of the House correctly, there is no desire that the ensuing proceedings be reported, and therefore members of the Hansard staff need not remain in the chamber. Mr. Speaker's note that the present time was different to the time that the conventions were agreed because there was no war then highlights the tension of the time, a nod to the need for a new precedent and a need to adapt, even if it leads to actions which are inconsistent with expectation and long-held convention. It may also raise some eyebrows in the audience that propriety is something apparently to be evaluated on an as-needs basis rather than considering the principles at stake. A half-hour debate was then had on the question that officers of the parliamentary reporting staff withdraw before the sitting was suspended. And members discussed the sort of meeting they were about to have in private. The member for Daly asked whether the discussion will be a glorified question time, horror, or an in-camera discussion of the Prime Minister's statement, and said that the decision to remove the reporting staff would very much hinge on the answer. Prime Minister Menzies clarified that the discussion would be on the statement, but noted that the House may agree to the printing of the paper on public resumption. Mr. Menzies said that he proposed the House met in private, as they have done before, that senators may attend and that they can make the paper public at the end if they need to, and they did do this. The member for East Sydney noted that no records had been kept of past private joint meetings, and these are not sittings, these are joint meetings, and that after these meetings, references were made in the House to certain statements made during the unrecorded time. The member for East Sydney said that without an official record, no one could establish what had been said. The member for East Sydney then asked whether members and senators would have access to the full supporting evidence in order to make their decisions during this time. He said, I want to know as much as possible of the evidence which is before the government and the Advisory War Council. Having excluded strangers in order that momentous questions may be discussed and confidential matters mentioned, every member of Parliament should be in a position to examine the evidence that the government possesses. The Prime Minister said that the secret cables between governments would not be circulated, so forget it. And discussion moved to the utility of Hansard for members and the importance of records. There was no dissent raised to the private meeting, but concerns were aired over members' own access to the official records and recordings of the debate for their own reference. Mr. Curtin highlighted that ordinary proceedings were one thing, but again, this was a time of war and sensitive information needed to be kept private. The members debated whether they would be able to publicly discuss the matters debated in private afterwards. With the following exchange between Mr. Curtin and the member for East Sydney, with Mr. Curtin saying, I see no occasion for Hansard to be present except for the purpose of taking such records of what is said in this place as are to be used by the people of Australia at large in judging us. Mr. Roseveare, the member for Daly, asked if the proposal could be discussed publicly. Mr. Curtin said, there would be no limitation except so far as an honourable member may say, I do not think I ought to use that as a reason for what I did. Mr. Roseveare says it's a method of gagging Parliament. And Mr. Curtin says, I have put up with it for some time, and while this country is in danger, I shall still put up with it. The government members say, hear, hear. This is a really interesting exchange, at least to me it is. Mr. Curtin's statement that Hansard is for when the people of Australia are allowed to judge the conduct of members is an interesting admission, and further that yes, meeting in private is a form of gagging debate, but it's one that Mr. Curtin will put up with. Mr. Curtin went on to refer to his responsibility to make decisions and his own weighing up of what should be made known to others. Drawing on the distinction between the Parliament and the people inherent in the discussion of the withdrawal of strangers, Mr. Curtin said that we, not the people, are charged with the government and safety of this country. In the minutes before the House ordered the withdrawal of strangers for the last time, the member for Barker seems to have had the last word. And I'll close this vignette with his reflections on sitting in private. He said, "I'm still very doubtful of the usefulness of secret meetings. They begin nowhere, go nowhere, and end nowhere. And the decisions which this country so badly needs will not be arrived at by these methods." The extraordinary resolution on 3 occasions to remove strangers from the House of Representatives so that, quote, momentous questions might be discussed in private has only been agreed to in times of war. By the members' own statements, the decisions made in wartime are different to those made in times of peace. Their trepidation to order with the withdrawal of strangers appears to grow over time, perhaps coinciding with the increased secrecy of the 3 uses of the order. The first time that the order is used, the House does not suspend and the votes and proceedings continue to record the proceedings of the House. The second time, the House is suspended. The third time, there's a lengthy debate on the nature of what's happening and the need for a private meeting before it's ultimately resolved in the affirmative. Although the tradition of public parliamentary debate was subverted during a time of crisis, the public could at least know that even if decisions were being made in secret, being based on information not accessible to the public, at least the parameters of the decision-making could be made known. Public trust could somewhat be maintained in the institution. There are numerous contemporary media reports which refer to the secret sittings, including the proposed times and dates that they may occur, many public and parliamentary references to the House of Commons sitting in secret. So the fact that they sat in secret was not itself a secret. There is perhaps a surprising lack of criticism for the occurrences in the media, which I think may be attributable to the distinction made between peace and wartime by members and the media. One news article from the time referred to the secret sittings of the British Parliament and said that it must always be remembered that in time of war, it's quite impossible for the public to be fully informed. There are many matters that have to be kept concealed from the enemy, and this can be done only by keeping them as secret as possible. For this reason, public opinion is occasionally wrong. So I finish by saying that sometimes it seems there is truly a desire that we be better strangers. Thank you.
Thank you, Aleshia, for that really interesting paper. Now, have we got any, I can't see that we've got any questions. Would anyone like to ask any questions of our presenters? No hands up. So would any of the presenters like to make any concluding remarks before we finish up?
Could I possibly apologise for my muting earlier on? When I get too enthusiastic, my computer likes to mute me, and it often happens when I'm presenting, so I'm sorry about that.
No worries.
Can I ask a question of Raqeeb or not?
Yes, please.
There is this whole idea behind having AI generated research, and it occurs to me that it could be a really handy tool if you're ploughing through Hansard on particular matters, but not being an IT expert, I'd have no idea where to start. So is this the sort of area where, for example, a legal academic might actually do well to collaborate with an IT expert in order to try and generate, I don't know, AI-driven learnings from themes in parliamentary debate?
Hello, so is that my audio working? Yeah,
Yes,
so
I
I think that some of the examples of the journal articles in my bibliography are exactly legal academics or political science academics that are collaborated with, I guess, either someone well-versed in quantitative research methods or from a computer science or IT area. So I think possibly that interest groups research that I've forgotten the name. One of the names was I think Professor Darren Halpin. I believe that he might be based I could be wrong, but I believe he might be based in a law faculty. But yeah, I think essentially a lot of those journal articles do describe how where they found their Hansard data, what they had to do to process it. And I guess also they often include complaints about the quality of the Hansard data and how they've had to overcome it. And then they, I guess, describe, how machine learning or AI generated methods, and I guess those more sophisticated statistical techniques has been useful for their research. Yeah.
All right, looks like we've got a question. Let me just have a look and see what it's from Colin Lewis. It says, Raqeeb, I am wondering if you think the depth and breadth of data collection available today, and as outlined so well in your presentation, will end up silencing people in the public life to a degree that is detrimental to a liberal democratic society?
I think some of that comes down to if you rely if you only rely on quantitative data, and often the data that you're collecting in bulk using these methods is just quantitative data, you're going to leave out all the things that I guess you lose the richness of qualitative information. I think partially, I think there's been some debate around theyvoteforyou.org.au. I think I've seen some media reporting around, it's while it is enhancing transparency and it's an instance of how open data is being used by the public today. There's also, actually, I think they acknowledge on the theyvoteforyou.org.au website that it can simplify, I guess, the way that Westminster parliaments actually operate and how Westminster parliaments actually come to decisions if you're just looking at the results of divisions, for example. And I think that's probably true for, I guess, anyone trying to rely only on effectively quantitative information. Does that was that what the question was getting at, or?
I think it's okay. Also, Rachel would like to say something about that question. Rachel, over to you. No, it looks like Rachel's on mute. We'll just give her a minute to see. No. Okay. Well, in that case, if Rachel can't come online with her question, if there's nothing else, then hang on a minute. There's another little thing. Oh, there's a question from Ken Kogel. I guess it's to all the presenters. To what extent, if any, are developments related to Australia's membership of the Open Government Partnership? Would anyone like to answer that?
I can answer that a little.
Okay. Go.
So I think for, I guess, what I wanted to do was, I think a lot of the discussion of the Open Government Partnership and what's come out of there, it's often a little bit abstract and it's a bit staying at the level of talking about standards and frameworks. So I think what I wanted to get a better understanding of is what does someone actually do with the open data once it's made available to them? And then from there, can you see what barriers currently exist or don't exist, or what factors there? And I think across some of the state parliaments in particular, it looks like executive governments have set up open data portals, and then some state parliaments are expected to then place their data on those portals. So I assume that's kind of all related into the general policy movement in relating to that Open Government Partnership.
Okay, thank you, Raqeeb. Hopefully that answered those two questions. Has anybody else got any other questions? If not, then I think this session is now concluded, and I'd like to thank very much our presenters for their very, very interesting presentations. And we can now hand over to session 5, Victoria Parliamentary Budget Office, if Jessica's ready to proceed.